Okay, welcome everybody to Safeguarding Matters Live.
Good afternoon. My name's Claire Turnbull, Designated Nurse for Safeguarding Children and Adults for the Integrated Care Board for Leicester, Leicestershire and Rutland. And this afternoon, I'm going to share with you an overview of the launch of the pre-birth and post-birth planning procedure for the Safeguarding Matters Live. This Born into Care series is dated, as you can see, 2018 to 2022. And the session that we're doing is about trauma in the context of parenting. And these documents will help you understand the context of removal at birth and what this looks like and the impact and how we can practice and support parents. This insightful quote from Judge Nicholas Crichton talks about the family justice system. So if that system's removing the fourth, fifth or sixth child from families without doing anything about the reasons for removal, it's a failing system. That for mothers and fathers, the younger the age of the child at removal, the greater likelihood there is of recurrent proceedings. So all of that happening again, a bit like the judge is saying about taking child after child after child. So if we're looking at a failing system, and we look at the next slide, this is actually showing to us about the age of children in care proceedings. And that's dated, as you can see, 2007 to 8, and between that year and 2016-17. A further 36% are issued at birth, which equates to a third of those children. And there's been a significant increase over the last 10 years in relation to issuing care proceedings within 7 days of birth, and it's doubled in this time. 47% of these babies' mums appeared within previous care proceedings, and the new research published last year says newborns are accounting for 50% of care proceedings. So we're talking about a high percentage of children taken into care and a high percentage of very young babies, and obviously the impact. The next slide is showing the findings here, and there are regional differences in the rate of the increase of proceedings. Short notice hearings have increased in England and Wales, and there's high levels of mental health needs. The impact of trauma can manifest itself in a range of ways. The kinds of things that you might see working with parents are substance misuse, domestic abuse, mental ill health. And if we only focus on the visible problems, the underlying trauma goes unrecognised, and therefore it's not addressed. Not understanding the role trauma plays can lead parents to struggling with their parenting in a way they never anticipated or never intended. So, you know, most parents want the best for their children. And as you can see from the findings, the reduction in preventative services, there's a higher threshold in order to get services, and the resource constraints affect the legal proceedings. Recruitment issues, delays in identifying need and offering services, fathers feeling marginalised or maybe invisible fathers, which we'll talk about later, and members of the family not included, and multiple experiences of trauma that I've just talked about. And there's also the position on the ward. We'll talk about all those areas as time goes on. So the timings of proceedings and the impact on bonding between those parents and the child, and the limited choices and impact of returning home without the baby. It's 1 in 4 mothers, so that's 25%, is at risk of reappearing in care proceedings following an initial set of proceedings, and that's within 7 years. And the experience of repeat proceedings is the greatest in a short period of time, in the first 3 years. And an interesting area of the prevalence is that 1 in 8 fathers in England is at risk of appearing in subsequent care proceedings within 5 years. So it isn't just the mothers, it's the fathers as well. And 50% of the babies subject to care proceedings within 2 weeks of birth are the children of mothers who've had previous children subject to proceedings within the last 5 years. The other thing to note is there are marked regional differences in the rates of reoccurrence, so it can be very different in different parts of the country. Many parents have experienced significant and multiple adverse experiences in their own childhoods. Used to be called ACEs, they're still called ACEs in some areas, and they're likely themselves to have been in the care system as well as children. Complex and unresolved trauma and the sort of phrases that are used about parents, hard to engage. And so this can lead to a misdiagnosis of emotionally unstable personality disorder, but actually what those parents are presenting with is multiple and complex trauma. So it's a traumatic event in itself, as I imagine that everybody would understand, particularly removal at birth or shortly afterwards when somebody's just had a baby and is in a very vulnerable position at that time. It exacerbates all sorts of parents' problems. So what can happen, and in interviews that we've had with parents locally as well, parents can lose benefits that they weren't expecting to, and housing, and tend to be suspicious of services and be of suspicion to services because of what's happened to them, being judged by what's happened to them. And evidence of complex grief, which I think is shown quite well in this cartoon to our right here. And the status of parenthood, they're still parents, and potentially ability to parent again. And the contact with the children living elsewhere is also important, and important to that baby if they've got siblings or half siblings as well. So subsequent proceedings when somebody's already lost a child is likely to be much, the child's likely to be much younger and completed much more quickly. So it's as if you're judged already on what's happened before, and the gap between those repeat proceedings often is very short. And children in second and subsequent proceedings are more likely to be adopted than children in index proceedings. So there's a sort of escalation, if you like, and adoption is more likely than other orders to lead to further sets of proceedings, and then problems with pre-birth assessments. So there's a lot to consider there with the impact of removal. The pre-birth audit that took place in 2023 to influence the procedure development. So a group of babies were identified for review, and that was based on cases where both parents or one parent had had previous children removed from their care. And there were 12 cases that were looked at, different organisations that were involved. So 3 local authorities, the district council, UHL from the point of view of maternity, the National Probation Service, where there were cases where families were involved with probation. There was living without abuse, where domestic abuse was a significant factor, and the Integrated Care Board, the GP records, and Leicestershire Partnership Trust, and also Turning Point, where substance misuse services were used as well. So there were positive examples of work, but there was room for improvement, and that was from all services really that we looked at. And many of the room for improvement linked to recommendations from the Change Project. So, for example, better engagement of families and dads and the support networks for families, better working with parents with a learning disability or a learning difficulty, better communication between services. And the Audit and Assurance Group are monitoring the recommendations from the audit, and uptake of multi-agency procedures was one of these, and also using things like the neglect toolkit and the domestic abuse toolkit. So that's a summary of the pre-birth audit. What I also wanted to cover now is our local reviews and the cases that have happened in Leicester, Leicestershire and Rutland. So the local reviews that influenced the development of the procedures. There were 4 cases across Leicester, Leicestershire and Rutland where 5 babies died between 2020 and 2022. And obviously that was over the COVID-19 period and lockdowns, etc. as well. And of those cases, there was some patterns of lifestyle and behaviour that were recurrent. So these women were homeless or had a recurrent housing issue or temporary housing. They had issues of substance and alcohol misuse, and some had been involved in sex work and used sex work to support their drug and alcohol misuse habits. And in all those cases, there were rapid reviews undertaken, and in one case, a local child safeguarding practice review, and still that is not published. And then we also had a baby that died in 2021. A mum was known to have had learning difficulties, and a rapid review was undertaken in that case. And then between 2017 and 2021, there were 2 babies who died one in 2017, one in 2021, and there was neglect seen in both of those cases. So all the learning from those local reviews have been used to improve our procedures. And obviously, as well as the national work, it's useful for people to know about the local work. This is all the procedures in one place around the issue, and there have been chapters that either have been enhanced or added in the light of what we've been talking about and what we've been learned nationally and locally. So the risks have been increased, the risk area, and there are new chapters, and one of them is chapter 3, working with fathers and partners and responses to trauma in the pre-birth period, and then chapters 10 and 11, planning for the birth and post-birth planning, and considering what can and what should be done if there's a separation at birth. So the first thing we're going to do is consider the working with fathers. So as you can see on the next slide, working with fathers and partners, and we're not trying to exclude partners who are not fathers, or partners who are not birth fathers, or female partners, but there is quite a lot of evidence in the research that was done in 2021, the myth of invisible men, to say that often men are invisible and we don't know enough about them, and they can present a risk to some fathers can present a risk to children. So there was research done in safeguarding children under the age of 1 year from non-accidental injury, and what has been developed alongside the procedures is a LLR practice guidance, and it's called Practice Principles Engaging Fathers and Male Carers in Effective Practice. And as you can see, there's the link there, but we also link the procedures into the working with fathers and partners. Separation at birth, that's also a significant chapter in terms of practice. So it's helping parents and significant others in their support, hopefully their support around them, kinship support or friends and family support, thinking about bonding and the timing of separation if that's what's going to happen, and giving them some power and giving them some control about how they would like this to happen. And how long they'll have with their baby, how they want that to happen. Do they want to walk out with their baby and put their baby in a car seat, or do they want someone to come and take the baby? That those situations happen in a private room, in a side room, so they're not people observing them when they're going to be very distressed. And also how to create memories and have a think about they were a parent and what they want to take from that and want to take with them, maybe some pictures, etc. And where carers have been identified, is it possible for the parents to meet the carers before separation if it could be helpful, and the aftercare of the mother? So the baby goes, and then of course you know the midwifery care is offered, but sometimes mothers don't want to be reminded of that. But obviously they won't have a health visitor anymore. So a lot of the people that were involved with the mother before she has the baby just disappear. Then they don't have a social worker, everything's attached to that baby that's now left her. So is there somebody there to offer support? Imagine going home to maybe cots and buggies and things that you might have got ready for your baby, and then you've got no baby when you come home. And the link to postnatal care, and to inform the GP that separation is the plan. So when to refer, these are some additional things to be considered. So where there's been a previous unexplained death of a child while in the care of either parent, partner or significant other. So we have had cases where maybe the partner has had previous children, but we don't know the details about those babies, and being professionally curious about things like that. When the degree of domestic violence is known to have occurred and is likely to significantly impact on the baby's safety or development. So that would be any unborn baby under 12 months, they're particularly vulnerable to violence, or practitioners who become aware of any incident of domestic violence in a family where there is a child under 12 months of age. So that would be, or in families where the woman is pregnant and they know there's domestic abuse, that is an automatic referral to children's social care. And where a current pregnancy has been concealed or denied by the birth mother, or where that has happened in the past. And then the other slide, as I said, there are two slides here. Again, a pre-birth referral should be considered where there are concerns that the baby may be suffering or likely to suffer significant harm. including a parent or partner previously suspected of fabricated or induced illness in a child that was previously called Munchausen's by proxy, or a prospective parent or partner has been subject to FII, as it's now called, as a child themselves. So the referrer should be able to identify the risk to the unborn child due to the impact of FII on the parental partner. So we're not saying a referral would definitely be made, it's about considering a referral in those circumstances. And concerns that the parent or the partners are rejecting medical advice or treatment which might place the unborn baby at risk of significant harm. Or a pregnant person who is prevented from accessing or fails to engage or actively avoid services that support them and the pregnancy of the unborn child. So when I talked to you about the previous cases locally of the ladies that were sex workers and had fluctuating home circumstances, they did fail to engage, but also in some cases had partners who were preventing them from accessing, or their lifestyle was preventing them from easily accessing services. There is an unborn child with a child protection plan, so the mother will be highlighted and then the baby will be on a CP plan when they are born. These are important points to note. Once the unborn or born child is on a child protection plan, the safeguarding unit in the local authority should add the Child Protection Information Sharing Alert, CPIS alert, onto the mother's before she has the baby, or the newborn baby record. And what happens when this alert has been put on is that safeguarding alerts go to the social worker should mothers present in an unscheduled health setting. So that's not every health setting, it's an unscheduled health setting. And that's why I have bullet pointed all those different areas. So that's like if they turned up an emergency department, and that should be the same if it was over the border, a walk-in centre, minor injuries, the ambulance service, GP out of hours services, and the 111 line, and also direct access to paediatric wards. And if GPs and health visitors have been invited to previous safeguarding meetings, they should link the birth notification to the safeguarding concerns. So that means if women go to other services to avoid suspicion, the CPIS should kick in, and that's why I've explained it in more detail. And it's an issue in the audit as well, just to say in the audit that was undertaken that GPs hadn't been invited to case conferences in time, or not given time to give a response. So it's having all of that information available to you in that pre-birth period, including the history. And unborn babies subject to a child protection plan. A pre-birth professional safety planning meeting for the hospital admission should take place no later than 36 weeks of pregnancy, and if possible take place by 32 weeks or as soon as possible if it's a late referral, and obviously we do get late referrals, and if labour is imminent prior to the estimated date of delivery. So the other thing to consider is women who've got certain substance misuse problems might deliver earlier because of the impact of their substance misuse, things like cocaine. And the separation at birth also comes into this chapter. And this is talking about the Phoenix team and the advice from Turning Point. And it's also holding a meeting in the best way for agencies and family members to be able to take part and to be coordinated virtually if that's a good solution for that. So the next slide is talking about post-birth planning, and the planning is for the baby to be safely discharged from the hospital, considering current and new and emerging risks and identified safety. And the meeting should also include agreeing the plan post-discharge. So this is not just the date of discharge, but where the baby will live, who the carer is going to be, and significant other carers for the baby. It talks about the roles and responsibilities of the family network, what support they can give, any restrictions on contact, and the roles and responsibilities of the different professionals that are involved, including when they visit in the initial period after birth and the date of the next core group, and when the parent will be able to see the baby, where separation is the plan, so the venue and how that will be arranged, transport, etc. where the baby or the parents or as significant others will see their baby post-discharge, and what information would the parents like to share. So that may be how the baby likes to be held, what the baby likes to wear, or what the mum likes the baby to wear, or the dad, and feeding regimes, that sort of thing. Some families, the families that will always benefit from a safe discharge planning meeting, and that will include where the baby is subject to a legal application, where there are specific concerns that have emerged since birth. So that could be observations by the staff on the ward and documented in the parenting log. So, you know, some information about maybe how the parents haven't interacted with the baby or haven't followed instructions or have been absent, etc. Where the baby is showing signs of withdrawal of substances and monitoring post-discharge. So again, additional information and resources have been added into the procedure to talk about different drugs and how the baby might present and at what time, because sometimes that withdrawal isn't immediately after the baby's been born, but some days after. So there may be a need for more support for the carers about how to look after that baby, or there may be a request for delay in discharging because the baby's got signs of withdrawal from the drugs. And where parents require specific support with their parenting from either the family or safety network, which requires multi-agency planning. So that might be monitoring of the parents, it might be who would take a priority there. And where there are professional disagreements about the discharge plan, there's a clear escalation process that should be identified to ensure it's resolved prior to discharge. And if this cannot be resolved by discussion between appropriate line managers, to use the formal LLR escalation policy, and the baby remain in hospital until a resolution is possible. So the Change project actually also developed best practice guidance, and it is quite long and it is quite complex, but it's helpfully structured into 3 sections or periods of time, and those are pre-birth, so that's from conception to labour. And then there's where the practice is focused on the maternity setting and up to the first court hearing. And then the final section is leaving hospital and returning home. And so there are various statements around the organisational structure, the processes, and also practitioner practice in those 3 separate periods of time. If we just look at the procedures, those are all the different bits of the procedures. There's the pre-birth and post-birth planning in procedures online. There's the pre-birth pathway. There's the disagreements, the information sharing, children and families that move across boundaries. Obviously, for babies that are born in Rutland, they can often be born in another area, say across the border in Lincolnshire or Nottingham, for example. Then there's the non-accidental injury, and the practice guidance and principles of working with fathers like we talked about earlier. And then other resources also include videos from research and practice. So if you wanted to know more about the Change project, you can have a look at those and the background. SUDI information, safe sleep resources, the ICON website. And then in particular, this is a useful document, risk of harm to children in your household. So that's giving guidance to parents about how to keep drugs and alcohol and other substances safe and away from children, and risk of harm, which is quite useful. And then the whole research and practice talking about parents who are disengaging and reconceptualizing non-engagement in terms of a trauma-informed approach. Thank you very much for your time.
A joint effort, a joint presentation from Alison Taylor-Prow, who's from the ICB. She's the designated professional for safeguarding adults across Leicestershire and Rutland, and also Javiria Shirazi, who's the safeguarding team leader from Leicestershire Fire and Rescue Services. So I'll hand over to those. Thank you.
So I'm known as Jab within Leicestershire Fire and Rescue Service, and what I just wanted to really talk to you about was just the referral pathways that we have within the service, within Leicestershire Fire and Rescue Service, and what we potentially are offering at the moment as well. So this is hopefully something that you've all seen before, and this is a national framework that we all use. So all fire and rescue services within England, Scotland, Wales use this framework, and whenever you do make a referral, please try to use this as a guide in order for us to determine the fire risk. So if it is within the red, so if it's a 7, 8 or 9, that does warrant an automatic referral to adult social care as well as to the fire service as well. We would ideally like referrals coming in when you have concerns around 5 and or 6, but please do ensure that if it is a 7 or a plus, it should not just be the fire service we're making those referrals to, as it needs to be a multi-agency approach. Try to make contact with the GP as well as adult social care, as then we can collectively try to work with the person involved in hoarding behaviours. And just so we're aware, if it is 7 plus as well, we do not always need consent for those referrals coming through as well. Could I have the next slide, please, Martin? Now, this is one referral that we received, and I've obviously blocked out the person's name and identity, but if we look at the concerns, the only information that we received for this one referral was this person is hoarding newspapers in the property. This poses a fire risk. And that's all we're sometimes told with these kind of cases that we get. And I can completely appreciate that they are very complex, and sometimes you do have resistance from the person when you are making a referral. But when we actually visited the property, this was what we saw. If I could have the next slide, please, Martin. So what wasn't mentioned was, so first of all, we know that there's a lot of newspapers in this property. It did say within the previous slide that this person is hoarding a lot of newspapers. But if I can ask you, Martin, to click on the slide first, if that's okay. What wasn't mentioned was that this person was using a halogen heater as a source of heating their own home. So when we do have people that do have hoarding behaviours, they do find it a struggle to heat up their room. And what you do find is sometimes people are using only one room to heat up their room. So what wasn't mentioned at all was they were using a halogen heater. If you wouldn't mind clicking it again, please, Martin. And that there were lighters present, and this person was a heavy smoker. During the course of me actually visiting this gentleman in this one property, and he has consented for me to share this photo, there was a spoon that was wedged in between those newspapers, and he was actually using a spoon as a source of an ashtray. So we can appreciate the dangers that are involved, the high fire risk, and I'm not expecting anybody within this room today to be fire safety experts, but let's just try to observe a bit more, and so that we can share that information, as when we are reading this referral, we are effectively reading it behind a screen. So as much information as you may feel is relevant or not relevant, please do share that so that we can build a picture when we are receiving those referrals as well. So there were lighters evident in this one picture as well. What we couldn't see was the alcohol cans that were on the floor in this one premise. So this person was a heavy drinker as well. And these are the information that we were not told when we did get this referral come through. Yes, they all have an implication to high fire risk, but the drinking and the smoking just heightens the risk further for us. The halogen heat is a source of heating, especially in autumn, winter time. We could possibly look at other avenues to make sure that this person is warm but safer in their property as well. And finally, what was not mentioned was the, yeah, Martin, if you wouldn't mind clicking, is the clutter rating as well. So please try to just give us an idea of what the clutter rating is. Fully appreciate once again that it may vary with your decision making. So some people may class it as a 7, some people may class it as an 8 or 9, but it's just to give us a bit of an indication of what the clutter rating is, so that we're aware when we are entering those properties what to expect. So just a bit more information would really, really help when we are trying to make those healthy safeguarding referrals to all partner agencies as well. Now, what's been identified during my time as working as a safeguarding lead for the service is that there actually isn't enough support out there for people with hoarding behaviours. And what we've done within the fire service, it's been ongoing for nearly 2 years. We've created a hoarding peer group within the service. Martin, if you wouldn't mind clicking the next slide for me. Now, this is a group that's run on a monthly basis, and it's on the last Wednesday of every month. And this group is literally just there to offer a bit of support to people that do have hoarding behaviours, as it's been identified that there really isn't much support out there. Now, we've got a healthy number coming to this group, and what we do is we just have open and honest conversations about their feelings, about the challenges that they face, and try to kind of break down those barriers as well. So it's at a city station on the last Wednesday of every month, and it's at 2 till 3:30. If you do know that anybody who is hoarding would be interested in coming to this group, please do drop me an email, and it's a safeguarding inbox, the safeguarding email that's at the bottom of this leaflet, or by all means contact the fire service and ask for Jav, and I'll be more than happy to have a conversation with you. And the reason for that is because it can be very hard for somebody who has hoarding behaviours to almost accept help, to go and talk about their problems and challenges that they have. So we try to have a meet and greet where we meet somebody outside and welcome them in, and also to try to make it as easy as possible for them to have conversations. Sometimes when people come to these groups, they don't want to say anything, they just want to listen, and that's okay. Sometimes people come and they want to almost talk about their problems and everything all in one session as well, and that's absolutely fine. It's led by them, and we don't like to almost label people. So what we've called the group is My Space at My Pace, and that's something that they decided to name the group as well. So the purpose of the group then, if you wouldn't mind clicking the next slide, Martin. The purpose of this group then is for the people to talk about the day-to-day challenges, is to combat loneliness and to empower them to be able to speak, to be able to share their daily struggles, to be able to feel comfortable and confident talking about hoarding behaviours, and just normalising the lifestyle that they have. Yes, there are risks involved, and we do talk about that, but almost trying to make them feel comfortable about talking about their struggles, as it's not a comfortable conversation to always have. And it's an opportunity for them to meet other people who live a similar lifestyle. The feedback that we've had from a lot of them is that they didn't have any idea that there were other people living this kind of lifestyle to them. We have guest speakers coming as well, and that's just to make them, the service users, aware of what services we have. So we've had somebody from the GP come, a social prescriber, we've had Samaritans come, somebody from housing come, just to talk about the services that are available as well. We also have a representative from Adult Social Care attend, and they are the hoarding specialist social worker who work primarily in the city area. And then we have a representative from Safe Spaces also attend the group on a monthly basis. And that's to build on the trust as well, to break down those barriers and build on trust, have a familiar face come in, so that hopefully they will allow other agencies to enter their homes as well, in order to access help and support that could be available to them. And it's also to educate the community, finding ways in which we can educate the community, and also to educate professionals as well. Now, the next slide that I'm going to show you is a video. It's an audio that was designed by people within the Hoarding peer group, and it's about their voice, and it's about the struggles that they face, and it's about almost listening to them, because sometimes people that hoard, their voices are lost within the clutter that they have in their home. So it's about educating ourselves as professionals as well as a community, but listening to them, making it person-centered towards them. So let's put this on the next clip then, Martin, if that's okay, and hopefully you've all got your sounds on as well.
Ashamed but want to be different. Overwhelming.
People assume you have chosen this lifestyle.
Isolation. Hoarding is not a dirty word.
In grief, I find comfort in possessions.
My hoarding is not rubbish.
Conflict, blanket distress.
Conflicted.
Insecurity.
Trauma, emotional events that have actually are the root cause that have set individuals to then become hoarders.
And that was something that was designed by the people that come to the group. So it's not my voice that runs the group, it's the people that are living through this day in and day out. It was just to give you a brief introduction, I guess, to what the Hoarding peer group do and offer. The group is hopefully going to be expanding, and we will hopefully try to run something within the county as well, and that will be in conjunction with Safe Spaces. But if you do have any questions or concerns or anything that you would like to talk about, please do get in touch with me. My details are on the next slide, but alternatively I believe that the slides will be shared, and you know, it's there for everybody to access as well. Thank you for all the claps and the love hearts, and I'll pass you over to Alison as well. Thank you very much.
Thanks, Jav. So I'm gonna do my presentation on how some of this translates into practice for health and social care workers and people who might be going into the houses and providing support to people who hoard, and that can be really across adults and children's services, and thinking about hoarding and the MCA. So next slide. I'm going to look at how and when to use the MCA when somebody with that we're working with presents with hoarding items, and they might be at risk of serious harm, or just like Jav said, harm, obviously using the hoarding tool to look at the risks, but also looking to support decision making with them and working with them collaboratively where possible. So there's some case law that from 2022 that I'm going to talk about, and then think about this in practice and some of the other factors that will impact on our thinking around these cases. Next slide, please. So AC and GC was a case that was heard in the Court of Protection. There's a link to the judgment, which is, as ever, long. So I've just pulled out points, really, that we can look at today quite briefly. The background of the case is that AC is a 92-year-old woman, and she'd been sharing a home that she owned with her son, GC, since her husband's death 11 years earlier. And GC had given up his job and become his mother's main carer. In February 22, she was taken to hospital by emergency services, and in March 22, she had a best interest decision to discharge her from hospital to a care home, and there'd been concerns about how unsanitary the conditions at her home were and the impact on her health and welfare. So in the summer of 22, it went to the Court of Protection to look at whether she could return home for a trial period with a package of care. It was her wish to return home, but the local authority thought she should remain in the care home. So it went to the Court of Protection to settle that disagreement. Both of AC and her son were diagnosed as having hoarding disorder, and I think the son also was diagnosed with OCD, and I'll talk a bit about the diagnosis element later in the presentation. And they both had their own social workers. Next slide. So this is a statement around the Mental Capacity Act, just to refresh everybody. And I know we go over this again and again, but it is important to just think about the basics, about what we're doing and why. So legal capacity depends on the applications of Section 2 and 3 of the MCA, together with the principles in Section 1. It doesn't depend on the wisdom of the decision. Furthermore, an important purpose of the MCA is to promote autonomy. That purpose aids the interpretations of Section 2 and 3 of the MCA. If P has capacity to make a decision, then he or she has the right to make an unwise decision and to suffer the consequences if and when things go wrong. In this way, P can learn from mistakes and thus attain a greater degree of independence. So that's that importance about promoting autonomy. But if we look at the next slide, there's also a really important balance here about why the MCA is so important, because actually it's a terrible thing to be said to have capacity when you do not, and to be left to cause yourself and those you love great harm on the basis that you know what you are doing and you're making your own choices, when in fact your decisions are not really yours. To have others harm you and to be told no protection is offered because you choose this harm, even though it is against your deepest values, is horrific. So Herring and Wall are law and ethics lecturers and do a lot of writing, and I I find this statement quite moving. So I thought it's just important to think about that balance between autonomy and that importance of carefully assessing capacity and thinking about best interests, and balancing those rights for autonomy, but also the rights that people have to be safe, and we all want to be safe, don't we? Next slide, please. So this is our bread and butter around the MCA. Now, there was a judgment, my mind's gone blank, I think it was 2020, the JB judgment, but it was a Supreme Court judgment. What's important is it's changed the order of the MCA, so that we think about whether somebody understand, retain, use and weigh and communicate the decision. Obviously, they've got to be 16 or over and have an impairment in the disturbance of the functioning of mind or brain. So we don't think about an impairment first. We think about whether they can make a decision, and then we consider whether it's to do with, if they can't make the decision, whether it's to do with an impairment of mind or brain. And it is a subtle change, but I think it's important because it helps us think about how we communicate with people and how we give them that relevant information to understand, retain, to think about whether they understand, retain, use and weigh and communicate the decision. Next slide, please. Now, I'm just giving a nod to the MCA here. In terms of the Hoarding decision, we're thinking about the first three principles, which are the assessment of capacity, and about giving that relevant information. So next slide, please. So when we've got somebody who's hoarding, we want to think about what is the decision we're asking the person to make. What are we thinking about? And AC and GC is important because the court defined the decision for us, and it seems really obvious, but I don't think I would have thought of it in that way if they hadn't put it so plainly. So the decision we're asking is whether the person can manage their items and belongings. So when we think about that, we can then go, if we go to the next slide, they've kindly broken down what information we need to give. So when we doubt that person's capacity and we start to think about the decision they're making, we assume they have capacity by giving them the information to discuss the decision, and then we think about whether we can establish they lack capacity or not. So this is the same tool that Jav put up. It's just, I think it's a different image to what you put up, isn't it? There's lots of different images. So you might doubt a person's ability to decide how to manage their items and belongings at any stage in this, but this is just helping you reflect on when you might start to question that. And as Jav said, it would be a definite concern in that lower range, the 7, 8, 9, but perhaps it might be in the other layers as well, because people start hoarding, don't they? They don't just accumulate lots of items very quickly. Generally, it happens over time. Next slide, please. So I won't read out all of this. It's available in the judgment, and then I think if the slides are coming out, when we're thinking about the relevant information, they identified 5 really important points. So the volume of belongings and the impact on the use of rooms, and then it talks about what that could look like when we're discussing that relevant information in terms of the impact of those belongings on how somebody can use the rooms in their house. So is it reserved to just one room? Is it in several rooms? And how much is it affecting the use of those rooms? You know, I've known of cases where people can't use their kitchen, can't use their bathroom, and then safe access and use. So again, like that photo, well, the photo I'm showing, and then the photo of the newspapers and the risks around that, was there access to living areas, but also access to exits in an emergency. Next slide, please. And then the creation of hazards, which is then how are the hazards, what are the hazards and what's the potential? So can somebody use the toilet? I've known of people using the fireplace as a toilet because they can't use their toilet because of hoarded items. The impact on health and safety in the kitchen, an ability to have a healthy diet, safe diet. You know, can people access the fridge, the cooker, and is that safe? I've known of people storing gas canisters and living above chip shops where there's a lot of there's a lot of heat generated as well. So, you know, it's dependent on the environment, but that creation of hazards is critical. And then next slide, please. The safety of the building in general. So that's internal and external. Sometimes people aren't able to take care of the external areas of the property, and it can have an impact on inside and outside, and also impact on others. And then there is removal and disposal of hazardous levels of belongings. So, you know, consideration of whether the person is able to use and weigh, particularly that the removal and disposal of the hazardous items, and that can be a really difficult one for people who hoard, especially if there's a really profound emotional attachment based on trauma. So these are the points that the court really broke down as the important points to consider when you're looking at somebody who's hoarding items. Next slide, please. So those practicable steps, in this case, work was undertaken over years, and I think the case had been to court a number of times. Both parties or members of the household had social workers reflecting the care and support needs, and I think they worked individually and together with them to support them. And then the fire service had been involved, and again, that practicable steps in terms of giving information. I'm certainly not an expert on safety in the home, fire safety, and the impact of stored items on safety and all the different elements of safety it can affect. You know, I've known people not maintaining boilers or trying to maintain them themselves. You know, there's lots of risk factors, and we can't be experts in everything. So really, it was, in this case, the judge commented on the collaborative multi-agency working and how well it was done, and the importance of the therapeutic relationships, and then that analysis of the risks that the multi-agency have identified. Next slide, please. So again, when we're looking at the Mental Capacity Act, we're then thinking, if we think somebody can't make the decisions, so they can't understand or retain or use and weigh or communicate their decision, if there's an inability, then it needs to be related to an impairment in the functioning of mind or brain. Now, that doesn't need to be a diagnosed condition, and you can have reasonable belief. So if you see somebody who's never seen services and not engaging with services, which is the case often in primary care, and that's what I see in primary care, they've not got any sort of known mental health problems or conditions, but they're self-neglecting or hoarding, particularly to a really significant level. It is reasonable belief that you might think that they're not able to make the decision. Next slide, please. So there is a diagnosis of hoarding disorder, and while we might not be able to make that ourselves, you know, we're not psychiatrists, and the GP might need to refer the person to mental health services. It's helpful to have just an understanding that there is a disorder, and there are defined symptoms of that. So that can help, that knowledge can help us be alert to the signs of somebody experiencing hoarding disorder. And it can be really around that very close relationship with the items that are collected, find it very hard to decide or get rid of items, and that emotional attachment preventing them getting rid of items and accumulating more items. Next slide, please. So there is a link and a commonality between OCD, obsessive compulsive disorder, and hoarding, and this slide just highlights the overlap between the two disorders. They are distinct and separate, but there is an overlap. So we don't need to worry too much about conditions that people might have, but it's just being alert to these facts, really, and thinking about it if we do come across somebody in the community, especially if they haven't been reviewed by mental health services. Next slide, please. So there, in this case, there was, and I'm not going to be able to pronounce it, there's lots of words I can't pronounce today, Professor Salkovskis, I've read it to myself but not said it out loud. So paragraph 21, he explained how serious it is when there's a combination of obsessive compulsive disorder and hoarding disorder. They're disorders which impair life, can cause much distress, and when the two interact, it is more serious, he said. It's like having COVID on top of asthma. And if you are interested, the judgment is really illuminating in terms of the factors that influenced the decision making of the court, and also the impact that the conditions had on the son and the mother. Next slide, please. So just being trauma informed as well, when we think about working with people, assessing mental capacity in people that are hoarding. Bereavement and trauma are a really key reason why people hoard, and it's having that trauma informed head on to just consider that impact on how, you know, the influence of that bereavement and impact on their mental health in terms of that loss. Next slide. And just to say, if you are interested, I didn't put it in this because I know we're limited for time, but the judgment did present quite a long best interest decision around allowing AC to go home. And even though a son was also assessed to lack capacity around hoarding due to his hoarding and OCD, they had a really robust care plan where he would get support, and he had certain conditions that he had to let people in to access her, that they would get support around the belongings. I mean, it was a really compassionate judgment, I thought, that really balanced her desire to go home and not be in care with actually quite assertive action planning around two people who were really struggling with their functioning. So thank you very much.
The next section is on child sexual abuse, or CSA. That's by Liz Dunn. She's the Safeguarding Learning Project Development Officer. That's a long title, isn't it, for Leicester, Leicestershire and Rutland. And towards the end of this part, we'll be joined by Leslie Booth doing her bit, and she's from Leicester City Council. Okay, over to you, Liz. Thank you.
Great, thank you. So if we can go on to the next slide, please, Martin. I just wanted to talk to you about the Child Sexual Abuse Roadshow that we held, prioritising child sexual abuse. So this was a one-day conference that was run by the Centre of Expertise on Child Sexual Abuse. It included lots of information and data, some of which I'm going to share with you, from the Centre of Expertise, who research and look at sort of trends and all those sort of concerns that we have. And we also had an expert by experience. So that was somebody talking about their experience of child sexual abuse and how it had impacted them through their life, some of the responses they'd had. They're an adult now, and how they want to sort of help professionals, practitioners, to understand what it might be like to be a young person, a child who's being sexually abused. And something really interesting that she said was that although her father was abusing her, she wasn't frightened of him. So if the expectation of a practitioner was that you wouldn't be in the room with your father because he was abusing you, or you wouldn't feel comfortable in his presence, then that wasn't actually how it was at all. But even though he was abusing her, she still had a level of love and felt so safe with him. She just wanted that sexual abuse to stop. We also had a presentation by the East Midlands Children and Young People Sexual Assault Service. So they were explaining the service that they had and how their agency ran and how referrals should go to them. So that was really useful. And this was last month, and we supported the safeguarding partnerships across Leicestershire and Rutland, supported this event. And it was a really good event to have, because obviously the Centre of Expertise on Child Sexual Abuse are the sort of experts in this arena. But part of the reason why they came to Leicester, Leicestershire and Rutland, was because we've got several different reviews going on around sexual abuse, some of which are being used in a national panel report. So it's good that they came, but there's a kind of background as to why we were an area where they wanted to come. Could I have the next slide, please? So sexual abuse is a massive sort of issue. More than 1 in 10 children has been abused by the age of 16, and this is much higher for girls than it is for boys. If we go on to the next slide, please. For girls, abuse by family members is more common. For boys, abuse by authority figures is more common. So these are the what the research tells us. Next slide, please. But what we know about sexual abuse is it's just as common as other forms of childhood abuse, but it's far less likely to be identified or named. So we estimate that 500,000 children are sexually abused every year. But if we look at how many then end up on a child protection plan due to child sexual abuse, it's considerably less. And we estimate that figure because of adult survivors who tell us about their sexual abuse in childhood. So we know, that's why we know about that there are more people, but it doesn't come to light so readily as other forms of abuse. Could I have the next slide, please? And these are the statistics locally. So this is the data set that was been done by the Centre for Expertise on Child Sexual Abuse. And you can see in Leicester, these are their statistical neighbours. So demographically, they're very similar. And so that you can compare different sort of regions, they've done it per child population. So you can see that Leicester has an average rate of assessments under the category of child sexual abuse at the rate of 22.4, compared with the average in England at 25.7. So that red line is the England average, and Leicester City falls below that in terms of children as assessed as being at risk. If we look at the next slide, which is Leicestershire, I believe, Leicestershire, you can see, is again falls below that England average. So again, this is statistical neighbours. The child population of West Sussex is broadly similar to Leicestershire. They assessed 42 children at a rate of 2.4, and South Gloucestershire is less than half of Leicestershire, and they assessed 256 children at a 42.6. At a rate of 42.6. Now, that's not saying that we're doing anything wrong. It's just to kind of think about why that we are assessing less children. And then if we just look at Rutland, that's the next slide. You can see that again, they're a lot lower than the England average. Of course, they have a lot fewer children. So, but if we're doing it at rates, then it's statistical neighbour at a rate of 8.8 compared to the average of 25.7. It's far lower than any of its statistical neighbours, whereas North Yorkshire is far higher. So, I mean, North Yorkshire will be looking at why are they so much higher. If we could have the next slide, please. But what we do know about child sexual abuse, both locally and nationally, is that professionals rely too heavily on children to verbally disclose. So what we ask children to do is tell us directly that they're being sexually abused, because it's very, very difficult to prove otherwise. It's very difficult to prove sexual abuse. It's that sort of weight of responsibility where you've got somebody's word against somebody else's word. So how do we then prove it? It's a very secret act. There's lots of coercive control involved of children who might love and trust the person that's abusing them. They might not, but they might do. They've got something to lose. They don't understand where to go and who to tell. And quite often they'll be told that the sort of family might be broken up if they do talk, and quite often that is what happens, because we want to protect children from this sexual abuse. So following that event, we're now going to look at what learning we need locally around child sexual abuse. And what we have got is a 7-minute briefing, and the link's there for you to look at it afterwards. And this is a thematic sort of briefing on some of the reviews that we've got locally. But I'm just going to look at the reviewing practice part of that, which is the bottom left-hand blue box. So if we could go to the next slide. This looks at what sort of we need to think about locally. So have you spoken to the child alone? And alone, that might mean alone, not necessarily in the house with somebody else there that could potentially be the abuser, even if they're in a different room. Have you recorded and reported if a child has declined the opportunity to talk or be seen without a carer? Why have they done that? It could be something and nothing, but let's get a pattern. When working with a child who's experienced past trauma, have you considered if current experiences are contributing to presenting behaviours? So is it the trauma from the past that has led them to be perhaps in the care of the local authority, so in a care environment, in a placement, or is it something that's happening there and now? So are we prepared to think the unthinkable? Have you shared information effectively between agencies? So don't assume that other people know. If you see something, we must share it. And this is something that comes up again and again in reviews, how we share. Because if we don't link those events together, we might not see the pattern of behaviour. Have you acknowledged that the challenges of balancing that confidentiality with safeguarding responsibilities? So as practitioners, we know we must always set up our relationships to be able to share information where we have safeguarding concerns. So we must still do that, even if the child doesn't want us to. And then finally, have you reviewed the impact of child sexual abuse and of any investigations on the child? So putting yourself in their shoes, thinking about how it might be for them, why they might not be telling you clearly and directly what's happening to them. But also, if and when they do, have you considered how that might impact on you and how you might feel about that and how that impacts on your work and where that puts you in terms of your relationship with other members of that family or that family network. So there's lots of things to think about within locally within the reviews that we've got here. And I'm just going to now hand over to Leslie to talk us through some local sort of reviews, I believe.
But a couple of cases, I think that, so just to follow on from Liz's presentation, I'm just going to reflect on two current cases that are open, that are live sexual abuse cases in Leicester, slightly changed, so they're anonymised. But I think they just highlight some of the practical things, some of the things that Liz has just been talking about. And they're going to cover things like retractions, because every single one we have is complicated. Not one single one is straightforward and easy. Needs a lot of reflection, a lot of thinking, and we're not always on the same page. So both of these situations are children who were at the time on child protection plans, but the whole core group and even managers within social care are not always aligned to the same sort of thinking. So we're going to cover a bit about retractions, safety planning. Networks are massively important. The relationship between neglect and sexual abuse and use of categories, and our use of specialist assessments. Liz has already focused on children in care as well. I haven't brought a case study of any similar one of that, but in Leicester City, we've done a lot of focus on sexual abuse in and out of the home, in and out of the home as in the family home, but also for children who are looked after. We have had quite an increase on our child protection plans, but only over the last year. So the stats that Liz has used since then, it's increased, and I think it's because we're acknowledging and looking, keeping our eyes open for risk. So the first case is about two sisters, roughly 10 and 14 at the time, and the 14-year-old girl alleged that she'd been raped by her stepfather. She lived with her mum and her stepfather. Nobody believed her. She told the school, who did believe her, and that went to the police, and there was an investigation. Through that investigation, it was said at the Child Protection Conference that she retracted the allegations. So the safety planning all dropped. There she was, back at home with stepdad and mum and her sister, a 10-year-old sister. That word retracted, and just pick up on that. Understanding retractions is really important. We've heard already how difficult it is for children to tell in the first place. Then everything that they're told, the worst thing happens. Everybody starts looking, starts talking, starts saying things about their stepdad. Mum's really upset, as they were already told. So it is said that she retracted. She didn't actually retract. She said she didn't want to take it any further because it was too upsetting, which is a really different thing than retracting an allegation. It caused quite a lot of disagreement in the professional network, because got to a child protection conference and some people felt there was not the threshold for a child protection plan, and other people thought there was. The chair decided it would be a child protection plan and it would be for risk of sexual abuse, and there needed to be safety. Internally, we needed a reflective meeting because some of the professionals that were saying they didn't want a child protection plan were internal professionals as well. So we did need to reflect on that, and we did that really quickly, thankfully. And we got a safety plan that separated the two girls and the stepfather. That needed a lot of work with the network. And that hasn't been straightforward because the network sometimes believe the young girl and sometimes don't. But really interesting, when she did have that network around her and there was a safety plan that kept her away from her stepfather, she then went back to the police and told them exactly what happened. And so that was, I could go on about that case study for quite a bit longer because it does evolve from there on. But I think they were the main reflections that I wanted to highlight, that understanding of retractions. And it's a very powerful word, and it's not always accurate. Use of the network, use of reflection. We all become emotive over child sexual abuse. It's horrible. It's difficult to understand, and it's difficult because we don't see it. We can see a bruise, we can't see sexual abuse. So that case, I think, really illustrates a lot of those issues. It also highlights, as does the next one, about this safety being, tell mum to supervise 24/7. Now, our experience and our training in sexual abuse does give, particularly mothers, as it usually is, they need the space to digest the allegations and the concern and everybody's reaction to that. Of course they do, because they're in shock. It's, as we've heard, it's unbelievable. They can't think that it's true. So they do need some time to come through that and some support to come through that. But actually, if those parents really cannot believe, then we have to question, can they be the person to supervise? And can you supervise children 24/7 in a household with somebody who is likely to be very manipulative because they've already done something that involves manipulation, etc. So the other case study highlights some of those dilemmas as well, slightly different. We had 3 children arrive in Leicester with their stepfather. Well, 3 children, sorry. The stepfather was a stepfather to the 14-year-old, and then the 3 and a 1-year-old. So the 14-year-old was the stepchild of dad. And so we got mum, dad, and the 3 children. They came from another local authority, and they had been living in Leicester for something like 3 or 4 months when they were referred to children's social care. Father had been imprisoned for 4 years for grooming through to full rape of a 13-year-old in another local authority. He came out of prison and they did an assessment, and the family, there was no further action after the assessment, and then the family decided to move, and they moved into Leicester. That was referred to us by probation, Mossiver, somebody similar to that, because he was on the sex offenders register, so it did need to be referred to us. We looked at the assessments and we didn't think they were as robust as we would want them to be in Leicester. So we had the difficult dilemma of a family who had lived together after this horrific crime, with not the level of assessment that we would have wanted. So we decided that did need to go through the child protection processes and went to a child protection conference. That also brings in the dilemmas and of safety planning. So what do we put in a safety plan for a man who is already living with these children and has done for some time? No obvious difficulties there, but a mother who's got very young children and a teenager. teenager had some additional needs, some vulnerabilities, learning needs. So safety planning had to be considered. We felt that mother couldn't supervise on her own 3 children.
It might be scent or behaviour issues, and they're outside. They're not in school.
Okay, sorry, somebody's not on mute. So the safety planning did have to be really thoroughly considered, and that caused, again, a bit like the first case, some reflection internally about what we could expect of the family to do. And it felt unfair to the family because they had lived together for a period of time before it came to Leicester, and our decision making was different from another local authorities. It wasn't another local authority. It was way off down south, so very different from how we work locally. In that situation, we did ask him to move out if he would. We can't force anybody to in these circumstances, but we asked if he would, and they wouldn't. And so we had to have a compromise with the 14-year-old living elsewhere at the same at different periods of time. So there was a combination of a safety plan that supported more the safety for the 14-year-old at this point. Not that we were ignoring the safety of the younger ones, but the risks seem higher given that he had groomed through till full rape of a 13-year-old previously. We also needed our own specialist assessment of him that we could commission, and we needed to use networks. So we needed to go against the family's wishes and share his information with other parts of the family so that they could be vigilant and they could understand what the risk was, as well as the 14-year-old herself understanding that risk. So neither of those cases highlight, but I just did want to highlight the issue around neglect and sexual abuse and the use of categories. Historically, we have perhaps felt more comfortable using other categories other than sexual abuse, because to use that category, we have to name it. And professionals on the line today might have recognised a change in sort of use of categories as we have gone through the years. So it's possibly been for a good few years now that we have really been focused on using the right category so that we're absolutely sure that we've named what, and we're all clear about what abuse we're talking about. But we've become increasingly aware of the combination of risk, and that mainly between neglect and sexual abuse. And quite often sexual abuse we find hidden, buried in worries about neglect, because the neglect's there, it's staring you in the face. And we do find sexual abuse sort of lurking in the background. Quite obvious, I think, when you've got a lack of boundaries with families, less routine, less safety with other people who might come in and out of the house. That's something that we've found, and it was quite interesting that was also part of the recent learning that we were given by the Centre of Expertise when they last did a presentation to us. They were saying the correlation between the two abuses. So whilst I'm not sitting here promoting dual categories in child protection conferences, we have changed over the years and are considering at times where it's absolutely necessary that we do use more than one, particularly in those situations.
Okay, so I think we'll move on to the next section. It's the second National Safeguarding Adults Reviews Analysis. It's presented by Jo Reid. She's one of the board officers from Leicester Safeguarding Board's office. Over to you, Jo.
Okay, so the second National Safeguarding Adults Review Analysis has been published partly at the moment. They're waiting until after the election, so we're expecting it to come out any time now. Just in case we've got any children safeguarding practitioners here who where this isn't a great deal of interest, I've put a link in the chat to the Child Safeguarding Practice Review Panel annual report that's just that I think came out in January, in case you want to have a look through that instead. So just to confirm about the criteria the Safeguarding Adults reviews. So they're under Section 44 of the Care Act, and the boards have to conduct a SAR where an adult with care and support needs has died or they've experienced serious abuse and neglect, and the board knows or suspects that the death resulted from abuse or neglect, and there's reasonable cause for concern about how the board, members or others have worked together to safeguard the adult. So quite strict criteria there. There's also another section underneath where a Safeguarding Adults Board can actually choose to conduct a review of any other case where an adult in its area has needs for care and support and doesn't have to necessarily satisfy some of the other criteria above. Next slide, please. Okay, the purpose of a SAR, so it's for learning and improvement. So to identify the lessons to be learned from what happened and to apply the lessons to future practice. So also we don't want to apportion blame or hold practitioners or organisations accountable within that process. There are other processes available to do that. Next slide, please. Okay, so this analysis looked at 652 Safeguarding Adults reviews between April 2019 and March 2023. And the most common types of abuse reviewed were self-neglect, which came up in 60% of the reviews, followed by neglect and acts of omission, which is 46% of the reviews, followed by domestic abuse, 16%, physical abuse, 14%, and financial abuse, 13%. Next slide, please. Interestingly, this differed to the types of abuse that come up under Section 42 inquiries. So neglects and acts of omission are the most frequent ones reported there, followed by physical abuse, then financial, material abuse, and then psychological abuse. Next slide, please. Okay, so good practice was identified, most commonly noted risk assessment and management, and then applying the principles of making safeguarding personal. So there's a little bit more under there, but I won't go into that in any more detail. Next slide, please. Okay, so I'll do a couple of these. So the practice shortcomings that were identified were around poor risk assessment and risk management. And that was in 82% of the cases they looked at, followed by shortcomings in mental capacity assessment. So you'll note that the boards have got mental capacity out training, which we're running at the moment, which if you haven't already enrolled in, then please give us a shout and we'll see if we've got any spaces for you. Followed by lack of recognition of abuse and neglect, and then shortcomings in making safeguarding personal. A few others underneath, but I won't go into those in any more detail. Next slide, please. Okay, so the key messages that came out of the analysis. Firstly, risk assessment. It's got to be explicit and comprehensive. It's an essential component of practice, as is a focus on proportionate risk management. And they've noted that it's vital that practitioners pay close attention to mental capacity and carry out capacity assessments where indicated, particularly where individuals disregard high levels of risk to themselves or others. Also, where there might be concern about executive function, for the an example being acquired brain injury or alcohol dependency. So they're quite complex areas, we're aware. And there is some training that we're going to be offering later in the year about more complex areas of mental capacity. Next slide, please. Okay, and then basically noting that there are so many complexities around adult safeguarding, illustrated by the long list that they gave us of some of the practice shortcomings. And they've noted that practitioners have to be confident and competent across a wide range of knowledge and skills. And they've highlighted quite heavily about the personal qualities that practitioners bring to their work. Compassion, kindness, care, empathy and sensitivity, all the soft skills, all noted as good practice, along with the commitment, dedication, professionalism, skill and diligence of practitioners. And to support practitioners, they've noted that it's important to reflect on the demands that safeguarding practice makes and to identify how continuous professional development can support our skills and development, and the ability for people to use their personal qualities in professional practice. Next page, please. Okay, and there's a note about the poor case coordination and information sharing, along with pressures on staffing and workloads, the availability of commissioned resources, and the absence of management scrutiny, training and guidance, and how these things can compromise the effectiveness of safeguarding. And then they've just asked that practitioners learn lessons from safeguarding adults reviews, both in their own locality and elsewhere, and draw on this to inform their own practice. Next slide, please. So what next really for us? There are 31 priorities that are going to be coming out in the full report, which is expected anytime soon. Next slide, please. And so we'll be looking at these as soon as the report comes out. We'll have a look and see how the recommendations affect Leicester, Leicestershire and Rutland. And then we'll have a look in November to see how we want to address these. So there may be a bit more coming out in future safeguarding matters about this, and also in our trainers network, where we're looking at train the trainers, people who work for their organisations. And that's it.
Thank you very much, Jo.
Thank you for listening.
Okay, we're going to move on to the next section. Electively home educated children, or EHE. It's presented by Ellen Collier and I think Andrea Tyler. Ellen is from Education Welfare Service. She's the manager, Leicester City Council, and Andrea Tyler is the Senior Coordinator, Inclusive Learning at Rutland County Council. Over to you two. Thank you.
I'm just going to cover the first slide. Sorry to jump in, Ellen.
That's all right.
If you just go to the next slide, Martin. I just wanted, we wanted to bring elective home education to Safeguarding Matters because there's been a report released recently from the national panel that look at child safeguarding practice reviews, and the link to the briefings there, and what some of the recommendations they've made sort of haven't been taken up by the government, but then, as you know, we had an election, we recently changed. So we're working towards looking at how those recommendations are implemented. But the interesting part about it is that they're interested because child safeguarding practice reviews have risen from 2% of the elective home education group to 3.5% of that group. So the amount of children that we're concerned about within that group has gone up. So I'll now hand over to my colleagues that will talk about elective home education.
Thanks, Liz. Yeah, so afternoon all, I'm Ellen Collier, the Service Manager Education Welfare at the City Council. So I'm going to run through some of the basic information about home education, and then myself and Andrea are going to talk about what happens locally. So our models are slightly different. So first of all then, what is a parent's duty in law regarding their child's education? Well, this comes from Section 7 of the Education Act, and it states that the parent of every child of compulsory school age shall cause him/her to receive efficient full-time education suitable to age, ability and aptitude, and to any special educational needs, either by regular attendance at school or otherwise. And it's the or otherwise that is important here. That's home education. We normally refer to home education as EHE for short. And if I can just set the tone right from the start here, a lot of home educating families are doing a really good job. In the city, we have home educating community amounting to what would be a small secondary school, actually, of children who are home educated. So a lot more children than there used to be. And lots are doing a very good job, but there are a small number, a small percentage who are of significant concern. And there is, just to reassure colleagues, quite a bit of contact between education welfare and our social care colleagues. So next slide, thank you. So can a local authority actually decline a request from a parent to home educate? There are very, very limited circumstances, but nevertheless, there are some situations where we can say, actually, we're not in agreement. So one is a child has a special school named in their EHCP. And if we receive a request from a parent to deregister their child so that they can take responsibility for the child's education themselves, we go through a process, a multi-agency conversation about whether or not we are going to be happy with the child being removed. Is the child going to receive a suitable education? Does the parent have the ability to provide themselves, make the arrangements? And in some cases we agree, and in others we don't. Also, if we've had contact with a family previously and served a school attendance order on a parent because we've been concerned that a child who's not on a school roll is not receiving an education otherwise, so they've been served with an attendance order previously, then we can actually say, well, no, that order's in place, you can't deregister your child. A parent would have to ask us to revoke the order. Another one is if we've got two parents with PR and they don't agree, there shouldn't be any change to the education status of that child until there's agreement, and that's either parents coming to mutual agreements, or one or both will need to go through the family court, and then it'll be in the order what the decision is. Looked after child there, I skipped over that one. Yeah, that's happened very, very recently in the city. We have a young child whose mother was home educating, and information has come to our attention. We are not happy that that child is being home educated, and that status was changed immediately when we looked at all the information. That child's actually now in care and will be returning to school. But those are the odd, exceptional cases, I would say. Next slide, thank you. So what should home education look like? Well, the guidance, the DfE guidance, and there's quite thorough guidance for local authorities and parallel guidance for parents. The guidance says an awful lot about what families don't have to do and very little about what they do need to do. So home educating families don't have to keep to school hours, have a timetable, follow the national curriculum. It can look very, very different. But there is some case law which is helpful in that it concludes that unless maths and English is being taught, that children are progressing in maths and English, then it can't be suitable. And you know, we rely on that case law in our work with families. It's very, very helpful. Next slide, thanks. So what's the local authority's duty? Well, actually, it doesn't come from a law on home education. It comes from the regulations around children missing from education, children who are not on school rolls. And so local authorities have this duty in the Education Act to make arrangements to establish the identities of children who are not registered pupils at a school and are not receiving a suitable education otherwise. And that's where our powers come from. So where a parent advises their child is home educated, and where the education the child is receiving, our view is that it's not suitable, that child is considered to be a child missing from education. And we then have a process that we go through, which culminates in a school attendance order, which I've already mentioned being issued. So that's an order that is issued to parents whose children are not on a school roll, and we are not satisfied that the child is receiving a suitable education. And actually, until a home educating parent, a parent who says they're home educating, we're not satisfied the child is actually receiving suitable education, until we serve that order, that is the first point at which a parent is compelled legally to engage with us. So as you can imagine, all local authorities are busy trying to encourage parents to engage with us and share information, and that can be a tension. But there was this High Court decision, Goodred versus Portsmouth City Council 2021, which is really helpful again. So that was a High Court decision that confirms that local authorities are entitled to ask for information. Next slide, please. So the Home Education Register, those who've kept abreast of the developments in this area may have heard about the register. It's something that has been delayed and delayed and delayed, but we are expecting progress, hopefully, with the new government, that this is pushed through. The will is definitely there. It seems unthinkable, doesn't it, to have children who are home educated and none of us know anything about them. It doesn't seem right. It's been subject to consultation after consultation, and my guess is that it will become law. But just to say that where we know about a child who's home educated, you know, just the fact that their child's never been in school, we do follow our normal processes. Once we know about them, they're effectively on our list of home educated children. I would say it's difficult to tell what difference therefore the register will actually make, because how many children will we find out about them and how will we find out about them? And I think it's going to be interesting to see the detail of that once they regulate for it, assuming they do. And the next slide, thanks. So safeguarding. When a good few years ago now, our colleagues in social care realised about the lack of powers and duties around home education, we were having quite a lot of contact with them and making sure that in their decision making, in their plans, they were not putting, for example, closing a plan saying this child will be monitored by the home education team, that there's no powers or duties to go into a home to see a child, to see the learning environment. You know, we are lacking in powers around home educated children, and making sure that safe decisions were made about children who are home educated. That happened some time ago, and we do regularly update colleagues, make sure that any new social workers, for example, know that. And again, the first point at which parents are required to satisfy us by law about the education they're providing, it's when there's a school attendance order. And it's only DFE guidance that parents should respond to our requests for assurance. You know, so DFE are very proactive and encouraging parents, but unfortunately there's no powers. Operation Encompass there, children who are on school rolls where there's an incident, schools will receive the Operation Encompass notification. Same with home educated children, and also children missing from education who aren't on a school roll, not home educated. So I get those emails as schools receive emails for children on roll, and then we consider the information in the police report to decide whether or not it impacts on our decision about suitability of education and if anything else needs to happen on our part. In terms of information sharing, data sharing, so health data for 5-year-olds, working hard with colleagues to get that back in place. We started to receive data about all 5-year-olds known to health. There was a bit of an issue. We're working hard to get that back, and also to share the education status of all children so that health services know that children are home educated when they are. And next slide, thanks. So just very briefly, and then I'll hand over to Andrea from Rutland. So our local process in Leicester, so we've got approximately 850 children at present, if we include the year 11, so actually of school leaving age now, but if we were to include them. But also a lot of turbulence in the city, in the home educating community, families in and out of independent schools, maintained schools, home education. So there's well over 1,000 in any given year period now. That's a link to our home education website on our Leicester City Council website. And in the city, we use a process of discussions and reports with parents to determine if the education they're providing is suitable. So that starts off usually with an education welfare officer conversation with a parent, sometimes in the home. More usually it will be a telephone conversation with an attempt to speak to the child, also to seek their views. Parents won't always talk to us though, I should just note. We then ask them for a plan. What is it that you're going to do for your child in terms of supporting their education? And then we ask for a report. The 6-month point, DFE guidance suggests annually. We think that's too long. So after the 6-month point, we ask for a report at the 12-month point, and then annually thereafter. And we can't be prescriptive about what we want to see from a parent. We have to be very open to anything that they're willing to share with us. The slide there is Liz, slightly wrong. The higher executive officers, sorry, I didn't spot that. It's home education officers. We have some home education officers in the city who have a teaching background. They're the ones who look at the examples of work, the reports, etc., and tell us if they're satisfied that the child's receiving a suitable education. Work very closely with education welfare officers. So I'll hand over to Andrea now.
Thanks, Ellen. Sorry I missed the very start, but I was here, promise. So obviously everything that Ellen said previously is relevant to Rutland. It's just the actual process itself that's slightly different. We've got just under 50 families home educated at the moment, so obviously much smaller numbers, but obviously we've got a much smaller population overall, so it's relative. Same again, we use process of discussions, reports, meeting with parents where they'll meet with us around deciding whether the education is suitable or not. Once we've got that decision or intention to home educate notified to us, that's usually by school, but we do have families sometimes moving into the area and they will tell us themselves that they're going to home educate, or we'll get notifications from other local authorities to tell us that we have children moving in who are being home educated. First thing we do is check our liquid logic system, the early help social care system, to check if there's been any recent involvement with the family, any historical concerns, any SEN concerns, or any family help type involvement recently, just to give us a kind of picture of the family. Our forms that come in from school highlight whether there's any safeguarding concerns or what kind of services might have been involved with the child while they're in school. So again, we have a little picture of the child before we make contact. Then we complete an initial triage assessment. So we do that over the phone. Has a RAG rating outcome, red, amber and green outcome. And those conversations are around the same sorts of things as Ellen mentioned. So were the parents happy to home educate? Do they feel that they've been forced into that decision for any reason? Why have they made that decision? What plan have they got going forward? What do they think the education's going to look like? Do they have support? Do they need support? So it's kind of looking at, are there any worries really? We also check on things like the age of the child. So are they at a potential transition point of their education? So are they going into year 11? Does the parent understand what that means for their education, their exams, things like that? Do parents understand that there might not be a school place for that child to go back to should they change their mind? And once we've completed that triage, we'll have a RAG rating of the case, and that RAG rating determines how quickly we'll see that child. Again, so that can be normally between 3 and 6 months. We would put out a letter to send to the parent to ask them for a review. We always offer those face-to-face, but we offer to either do that at home or in a neutral location, or we offer, if they don't want to do that, they can meet us by Teams, and they can obviously refuse all of that and just send us a report. But we actually have quite a good relationship with our families, and I think I see about 90% of them regularly. So that's really, really positive from our point of view. Parents that choose to send information rather than having a meeting tend to give you a very, very thorough report of what they're doing. They know what they need to provide. And as Ellen said, that that's difficult in itself. You're making a decision on what you're reading, but actually that's all our remit is. We don't have any powers to question that parent and make them meet us. We can go back and ask for more information if we feel we haven't quite got what we need, but that's pretty much all our powers are. The decision is then made either on that report or during that meeting. If it's a face-to-face meeting, obviously it allows you to kind of dig a little bit further if you've not quite got what you need, or to have a conversation with that parent and say, actually, I don't quite feel that I've got what I need, and actually I think we ought to meet again in a month's time. Or it would just enter the annual review process if everything's fine and working really well. All of our cases are reviewed at least once a year, and if we can get them face-to-face, that's what we would tend to do. So kind of that's the process in Rutland. It's pretty similar. The law is obviously the same. Is that okay, Ellen?
Yeah, thanks, Andrea. The last slide there is the links to the Leicestershire site. Our colleagues from Leicester were unfortunately unable to join us today, but very similar processes in Leicestershire as well. Yeah, so thanks, Liz.
Brilliant. Thank you very much, everybody.
How does elected home education work with travelling and fair circus sort of families? I don't know if anybody.
Yeah, we do have travelling families who opt to home educate their children, and we try to stay in touch with them so that we can still ask them for assurance, and certainly when we know that families are resident again in the city, we're in touch with them. So it can be a little bit more tricky in terms of not knowing exactly where families are sometimes, but yeah, absolutely they do, and it's exactly the same. If we're not satisfied, then we'll go through that process of resulting in school attendance order if necessary. And then what I didn't say is failure to comply with the school attendance order is actually a criminal offence, and then we have court cases based on that failure to comply. So yeah, we have numbers of those going through in the city every year. Some of them in relation to home educating families.
That was me. My name's Eileen Redding. I'm a looked after children's nurse. So that was my question. So would you be able to then enforce that they stay in one area for the schooling if, like you said, there was a court thing? Sorry, I think I misunderstood.
No. I mean, it's a school attendance order. If as a parent you fail to comply with the school attendance order, which says either register your child at school, which is named on the order, or satisfy the local authority that you are providing a suitable education, it's an offence. It's an offence. There's a court hearing and an outcome from court, but then you start the process again. It's not an order that has any ability to control the movements of a family, and you are back to square one. Yeah, so it's not a perfect tool by any means.
Thank you for that.
Okay, any more questions? Okay, if I can thank everybody for attending and for the presenters in doing that, but it's been really interesting. We do try to mix it up with adults and children, so appreciate you swapping to us to and from, but obviously there's a lot of crossover and as thinking families and so on. I noticed at one point we had at least 391 people present, so well done. Thanks everybody. Liz, is there anything from you?
No, I'd just like to say thank you to everybody who's contributed, both through presenting and from asking questions and being involved. It's really helpful. Thank you very much. And we will look through the chat afterwards. So if there's stuff we've missed, we might try to get back to you sort of individually or whatever to respond to some questions. Thank you.
Okay, thank you all.